contest under 168. Now, if Mr. Boies is correct, then what did the Supreme Court mean when it said the decision whether to conduct a manual recount is vested in the sound discretion of the board? What did it mean? Because according to Mr. Boies, once that decision has been made, and the next thing by statute you can do is an election contest, the court can disregard what the board did. Well, that's not discretion, sound or otherwise. That's meaningless, because as soon as the board acts, the court can disregard it. I suggest to this court that that is not a proper construction of Florida law. What Florida law says, not only with regard to canvassing boards, but in fact all fact-finding boards, is that when the legislature entrusts to a fact-finding board the authority to act, and that board acts within the scope of that authority, the standard for review is abuse of discretion. And that's what the statute says here, and that's what the Florida Supreme Court has told us when it said that the board has the right to act within its sound discretion. Now, once the court says that, we know it leads to one and only one conclusion. The standard of review is whether they abused that discretion. That's what discretion means. And we also know what the test is for whether or not discretion has been abused. It is the reasonable person test. The test is, can reasonable persons differ as to what that board did? And if they can, you cannot overturn it. If any reasonable person could have done what the board did, knowing what the board knew, it's not subject to being overturned. That's elementary law school fact. It's a simple principle, and we know it. Now, I suggest to Your Honor, and I will discuss it in greater detail with respect to each of the issues that Mr. Boies has talked about, that there is no evidence in this case of any abuse of discretion by any of the county canvassing boards that are being challenged. But first, I want to talk about Mr. Boies' cases. In my opening statement, I invited Mr. Boies to tell this court what case law provided that the review of an election is de novo in the sense that once a county canvassing board has decided not to conduct a manual recount or has conducted a manual recount, that the court can disregard it. Mr. Boies has provided the court with a series of cases, primarily early cases in the 1930s, 1920s. I don't suggest that that makes a difference. But I will tell the court this: if you read these cases, you will not find in any one of them any discussion of the discretion of a canvassing board and the right of a court to disregard it. It is not an issue in any of these cases. In State versus Peacock, there was no canvassing board involved. There was no discussion of de novo review. It is true that the court reviewed ballots, but this issue was not before it. In State versus Smith, there was no discussion of de novo review. There was no recount by a canvassing board. It was not an issue in the case. The issue in the case was the proof necessary to justify a recount. And with regard to by the way, Your Honor, I will not spend the time to analyze every case, but I will tell you that not one of the cases cited in the state of Florida by Mr. Boies is contrary to the proposition that I have presented to this court and that flows necessarily from the decision 2 weeks ago from the Florida Supreme Court, in which we were told that the board has the sound discretion to make that decision. And by the way, while the court only had reason to address the decision as to whether or not there should be a recount, the same necessarily flows from the identical provision of the statute with respect to what the board does in the course of making that recount. It, too, is within its discretion. And Mr. Boies also discussed the... Thank you. The Beckstrom case. Beckstrom case also had nothing to do with a canvassing board. And I mentioned the Beckstrom